One secret board meeting. One hidden resolution passed without proper notice. One director kept completely uninformed. And suddenly, the entire board decision faces legal challenge, governance collapse, and massive litigation risk. Under Section 171 of the Companies Act 2013, proper notice of board meetings is not a procedural formality. It is the foundation of valid corporate decision making. A company may approve borrowings worth crores, appoint key executives, authorize mergers, issue securities, or approve financial statements. But if notice requirements are violated, those decisions may become vulnerable to disputes, shareholder allegations, secretarial audit objections, regulatory scrutiny, and even NCLT litigation. Every director, company secretary, compliance officer, auditor, investor, and governance professional must deeply understand Section 171 because corporate governance begins not with resolutions but with legally valid participation rights in board meetings. Welcome to Corporate and Securities Law Compass, navigating law with clarity. Today we are discussing one of the most operationally important governance provisions under the Companies Act 2013, Section 171, dealing with notice of board meeting. At first glance, this provision appears very short. Many students read it quickly and move ahead. But in practical governance, Section 171 is one of the most powerful procedural safeguards protecting transparency, fairness, participation rights, and validity of board decisions. This provision directly impacts board functioning, director participation, decision legitimacy, governance integrity, litigation exposure, secretarial compliance, investor confidence. To truly understand Section 171, we must first understand the philosophy of a board meeting. A board meeting is not merely a gathering of directors around a conference table. It is the legal brain of the company. Major corporate decisions emerge from board meetings. Borrowings, investments, related party approvals, financial statements, compliance monitoring, managerial appointments, litigation strategy, and governance oversight all originate through board deliberations. Therefore, every director must receive fair opportunity to participate. This is exactly why Section 171 exists. Historically, governance abuse frequently occurred where dominant promoters or controlling directors conducted meetings secretly without properly informing other directors. Critical resolutions were passed through manipulated participation processes. Minority directors, independent directors, and nominee directors were sometimes intentionally excluded from discussions. This undermined corporate democracy inside the boardroom. Section 171 therefore acts as a procedural protection mechanism. Now let us understand the statutory framework in simplified professional language. Section 171 states that every notice of a board meeting shall be given in writing to every director at the address registered with the company, and such notice shall be sent by hand delivery, post, or electronic means. This sentence appears simple but contains extremely important governance principles. The first important phrase is every director. This means selective communication is not permissible. Every existing director is entitled to notice. This includes executive directors, non-executive directors, independent directors, nominee directors, additional directors, alternate directors where applicable. Failure to send notice even to one entitled director may create governance complications. Now let us discuss the phrase in writing. Oral communication alone is insufficient. There must be documentary traceability. Modern governance requires evidence. Companies should maintain proof regarding dispatch, delivery, email transmission, agenda circulation, receipt records. This becomes critically important during disputes. Now let us discuss registered address. Directors usually provide official correspondence details to the company. Notices should be sent to such registered addresses or approved communication channels. Companies frequently make practical mistakes here. For example, sending notice to old email IDs, using unofficial communication channels, failing to update director contact details, assuming verbal discussions are enough. These mistakes create governance risk. Now let us discuss electronic means. Modern corporate governance increasingly relies upon electronic communication. Emails, secured board portals, and digital circulation systems are widely used. However, companies must ensure proper delivery systems, traceable records, secure circulation, confidentiality protection, timely dispatch. Cybersecurity concerns also become relevant, especially for listed companies handling price sensitive information. Now, let us discuss the most important practical requirement: notice period. The Companies Act generally requires at least 7 days' notice for board meetings. This is one of the most critical compliance timelines. The objective is simple: directors require reasonable time to review agenda, study documents, seek clarifications, analyze risks, consult experts if necessary, prepare informed participation. Board decisions should not become rushed rubber stamp exercises. Now let us discuss the concept of clear days. Professionals must carefully calculate notice timelines. Improper computation creates litigation risk. Company secretaries should maintain strong calendar discipline. One common mistake involves counting dispatch date incorrectly. Another mistake involves ignoring time differences in international communications involving foreign directors. Now let us discuss shorter notice meetings. Section 173 and related governance framework allow board meetings at shorter notice for urgent business subject to conditions. However, additional safeguards become relevant, particularly where independent directors are involved in listed or prescribed companies. This is extremely important. Urgency cannot become excuse for governance manipulation. Now let us discuss practical examples. Suppose promoters suddenly convene an urgent board meeting approving related party transactions without giving proper notice to independent directors. Later disputes arise regarding governance validity and fiduciary breach. Section 171 becomes central to litigation. Now imagine another scenario. A company issues notice late at night before a major morning meeting approving borrowings worth hundreds of crores. Certain directors argue they had no reasonable opportunity to review documents. Again, governance legitimacy becomes questionable. This demonstrates why Section 171 carries enormous practical significance. Now let us discuss board meeting agenda. Though Section 171 specifically addresses notice, practical governance requires proper agenda circulation along with supporting notes. Agenda papers should explain transaction rationale, financial implications, risk analysis, regulatory impact, approvals required, related party concerns, compliance obligations. Poor agenda drafting creates major governance weaknesses. One-line agenda descriptions are dangerous. Directors cannot exercise fiduciary duties effectively without adequate information. This directly connects Section 171 with Section 166 relating to duties of directors. Now let us discuss secretarial standards. Secretarial Standard 1, issued by the Institute of Company Secretaries of India, plays a crucial role in board meeting governance. SS1 provides detailed operational guidance regarding notice format, agenda circulation, notes to agenda, proof of sending, video conferencing procedures, record maintenance, meeting documentation. Though Section 171 provides statutory foundation, SS1 operationalizes governance practice in detail. Every company secretary must master SS1 thoroughly. Now let us discuss video conferencing and virtual participation. Modern governance increasingly involves hybrid and digital board meetings. Especially after technological evolution and globalized business structures, directors often participate remotely. Notice requirements therefore extend beyond physical meeting logistics. Companies must provide video access details, secure communication links, technical instructions, participation protocols. Poor digital governance creates participation disputes. Now let us discuss practical governance dangers. Improper board meeting notice may trigger challenge to resolutions, shareholder disputes, NCLT proceedings, secretarial audit qualifications, SEBI scrutiny, investor distrust, boardroom conflicts. In serious situations, even banks and lenders may question authority behind approvals. This becomes especially relevant for major borrowings, security creation, merger approvals, financial statement adoption, capital raising decisions. Now let us discuss interaction with listed company governance. Listed entities face much stricter scrutiny. SEBI LODR regulations require advance intimation to stock exchanges for specified board meetings, especially involving financial results, fundraising, buyback proposals, dividend decisions. Therefore, board meeting notice systems must align simultaneously with Companies Act, Secretarial standards, SEBI regulations, internal governance policies. One missed timeline may trigger compliance violations across multiple frameworks. Now let us discuss practical role of company secretaries. The company secretary acts as procedural governance architect. Responsibilities include preparing notices, verifying timelines, circulating agenda, maintaining dispatch proof, ensuring statutory compliance, coordinating board logistics, recording minutes, preserving governance evidence. Weak secretarial control creates enormous litigation exposure. Now let us discuss practical drafting precautions. A professionally drafted board meeting notice should clearly specify date, time, venue, mode of participation, agenda items, video conferencing details where applicable, supporting notes. Ambiguous notices create governance uncertainty. One common mistake involves adding major agenda items at the last moment without adequate circulation. This undermines informed decision making. Now let us discuss practical due diligence implications. During mergers, acquisitions, IPOs, and investor funding transactions, due diligence teams often examine board meeting notices, minutes, agenda circulation, attendance records, approval validity. Improper notice procedures may cast doubt on corporate authorizations. This becomes particularly serious where borrowings, share issuances, guarantees, related party transactions were approved through defective meetings. Now let us discuss judicial principles. Courts generally emphasize fair participation, proper notice, good faith governance, substantive opportunity to deliberate. Technical defects may sometimes be examined contextually, but deliberate exclusion or governance manipulation is viewed seriously. Natural justice principles influence corporate governance significantly. Now let us discuss practical family business situations. Closely held companies often conduct informal governance without proper notices. Family discussions happen casually and decisions are later documented mechanically. This becomes dangerous during disputes among family shareholders. Suddenly, parties challenge years of board decisions due to defective procedures. This is extremely common in Indian corporate litigation. Now, let us discuss practical startup governance. Startups often move rapidly and treat formalities lightly. Board approvals happen through messaging apps or informal discussions. Initially, this may appear harmless, but during future funding rounds, due diligence, investor disputes, exit transactions, regulatory investigations, such informal governance creates major risks. Professional governance discipline should begin early. Now let us discuss independent directors. Independent directors rely heavily on proper notice and agenda circulation to perform oversight functions. Without timely information, risk evaluation weakens, governance oversight suffers, fiduciary duties become difficult to discharge. This is why listed companies must maintain strong governance processes. Now let us discuss penalties and legal consequences. Failure to comply with board meeting procedural requirements may attract penalties and governance consequences depending upon circumstances. But practical damage often extends beyond statutory penalties. Defective meetings may undermine corporate credibility, investor trust, regulatory relationships, litigation defenses, financing arrangements. Now let us discuss ROC filing interactions. Many board meetings authorize filings such as MGT 14, DIR 12, PAS 3, CHG filings, financial statement approvals. If the underlying board meeting itself suffers procedural defects, validity concerns may affect subsequent filings and corporate actions. This demonstrates how Section 171 indirectly influences broader compliance ecosystems. Now let us discuss hidden examination traps. Students often assume sending notice itself is sufficient, regardless of timing. Incorrect. Notice period matters. Another misconception is that informal consent cures every defect automatically. Not necessarily. Governance context and statutory requirements matter significantly. Another hidden issue involves distinction between board meeting notice and general meeting notice. Both operate differently under company law. Careful conceptual clarity is essential. Now let us discuss practical litigation analysis. Suppose a company approves preferential allotment through board meeting conducted without proper notice to one director. Later, minority shareholders challenge allotment validity, alleging governance manipulation. Courts may examine notice dispatch proof, email records, agenda circulation, director participation opportunity, meeting urgency justification. This demonstrates evidentiary importance of procedural compliance. Now let us discuss interaction with Section 173. Section 171 works closely with Section 173 dealing with board meetings. Section 171 focuses on notice. Section 173 governs frequency and participation framework. Together, they create procedural foundation for board governance. Now let us discuss governance philosophy underlying Section 171. Corporate governance is not merely about outcomes. It is also about process legitimacy. Even commercially beneficial decisions may face challenge if governance process becomes unfair or procedurally defective. Section 171 therefore protects participatory governance, collective deliberation, board transparency, director equality, Institutional accountability. Now let us discuss one powerful practical illustration. Imagine a listed company facing financial crisis. Promoters urgently push through related party financing arrangements without properly informing independent directors. Months later, insolvency proceedings begin and forensic investigations reveal procedural irregularities in board meetings. At that moment, Section 171 becomes far more than a notice provision. It becomes evidence of governance integrity or governance failure. Ultimately, this provision teaches one powerful corporate governance principle. Directors cannot discharge fiduciary duties unless they receive proper opportunity to participate in informed decision making. A board meeting notice may appear like a routine email or formal communication, but legally, it represents the gateway to valid corporate governance itself. For company secretaries, Section 171 defines procedural governance discipline. For directors, it protects participation rights. For investors, it strengthens governance legitimacy. For regulators, it ensures transparent decision making. For advocates and governance professionals, it becomes critical evidence during disputes and investigations. And for every learner of corporate and securities law, Section 171 remains one of the clearest examples showing that in modern corporate governance, procedural fairness is not a technicality. It is the foundation upon which boardroom legitimacy is built. If you like this video, kindly like, subscribe, and hit the bell icon for latest notifications from Corporate and Securities Law Compass. Like, share, comment, subscribe.